Good morning, Advocate. I must confess that I'm not entirely sure that I had obtained a full curriculum vitae from you. I might have been remiss in doing that. You are currently the Director of Public Prosecutions in the North Gauteng Division, correct?
Yes,
And how long have you had that position?
from 2006.
And prior thereto, you were?
Prior to that, I was the Director of Public Prosecutions for the Northern Cape Division in Kimberley
And for how long was that?
from 2003.
And prior to that?
Prior to that, I was a Deputy Director of Public Prosecutions
In which division?
in the Directorate of Special Operations, the Scorpions, as they were called then.
And from which year were you there?
From 2000, from 2000 and from year 2000.
From year 2000.
Yes.
And prior to that?
Prior to that, I was a senior state advocate, still in the Directorates for Special Operations from 1999. So I was a senior state advocate from 99 to 2000.
And prior to you being admitted as prior to being a senior state advocate?
Prior to that, I was a district court magistrate in Amtata from 1996 to 1999.
And before you became a magistrate?
I was a public prosecutor from 1990 until 1996.
Did you commence your career as a public prosecutor?
Well, after qualification, but I was already in service because after matric, I got a bursary and started working. Went to school full time and worked during holidays. But upon qualification, I then became a public prosecutor in 1990.
And what are your academic qualifications?
I've got a B. Juris and LLB degree from the then University of Transkei. I've got an LLM degree from the University of Cape Town. And I've got a management program, development program from the UNISA Business School of Leadership.
And Advocate Mzanyati, when were you admitted as an advocate?
Must have been 1999.
And tell me, have you acted in the position of Deputy National Director of Public Prosecutions at all?
Yes. I acted as an acting Deputy National Director in year 2007. I then acted again for a short period. I went back to my office and then I acted again from 2017 until August of last year, 2018.
Advocate Mzanyati, there are 3 bits of evidence which pertain to you before this inquiry. You did an affidavit in a application brought by the General Counsel of the Bar dated 4 May 2015, correct?
Yes.
You also did an affidavit and confirmatory affidavit which you were asked to do dated 10 September 2013 in the Freedom Under the Law versus NDPP and others matter, correct?
Yes.
Right. You also gave evidence in the disciplinary proceedings which was instituted against Advocate Glenis Breitenbach in 2012, and you gave that evidence in January 2013, correct?
That's correct.
Right. And you were called as a witness by Advocate Mokgoro in that matter,
Yes.
correct? Right. Now, that bundle of documentation is before you, and I think one of my juniors has flagged where each one starts. You see the flags? You've got
Yes.
Right. The other document, the other bundle which is before you, is a bundle relating to a bundle of documentation relating to memos and stuff, which if I take you there too, I will refer to specific pages to jog your memory. We are very mindful that we're asking you to give evidence of events that transpired several years ago. Okay?
Thank you.
So maybe the first thing to take you to is your affidavit in the GCB matter. Advocate Mznyati, as you clarified in paragraph 8 of the affidavit on page 3,
Yes.
you were not party to the proceedings in the, I'll call it the freedom under the law, the full matter at all, correct?
No.
You were asked to attend a consultation at Chambers with Advocate Halgrein on one occasion during those proceedings, correct?
That's correct.
At the time when you consulted with Advocate Halgrein, was there any indication given that you were going to have to give an affidavit?
No.
Right. You then subsequently attended at another consultation. Is that correct?
With?
Advocate Houdis.
Yes.
Right. Was there any indication at that consultation that you were going to give an affidavit?
No.
Right. I want to take you to page 10 of your affidavit. Sorry, it's going to be the page that is marked on the right-hand side of the document and not necessarily the SCA record page number which you see on the left-hand side, which I'm
Yes.
going to be referring to, just so that it's clear on the record what I'm doing. At the time when the events occurred between 4 and 9 December 2011, you were the Director of Public Prosecutions in the North Gauteng Division, correct?
Yes.
Right. At that period, was there anybody in the office of the NDPP? Advocate Simelane, the judgment had been delivered in respect of Advocate Simelane on 1 December 2011, and these events take place that week ensuing.
During the period that you've highlighted, nobody had been appointed either as an NDPP or as an acting NDPP.
Now, prior to the 5th of December, before you and Advocate Mkhwebe has a conversation, you are aware that there is a prosecution ensuing in respect of Lieutenant General Mluli, correct?
Yes, I was aware of that.
And you'd been kept apprised by the prosecutors as to where the progress in that matter was.
Yes.
And those prosecutors would be answering to Advocate Breitenbach, and Advocate Breitenbach would be keeping you informed.
Yes.
That's the chain of communication.
In fact, the briefings, if we were to call them that, I was getting them from Breitenbach and Advocate Smith.
Now, you detail for clarification, you are not involved in, at that stage, the matters relating to murder, attempted murder, intimidating, kidnapping, assault, or defeating of the ends of justice, that fell under the jurisdiction of the DPP salt cutting.
That's correct.
And you had nothing to do with that matter.
That's correct.
Right. Now, if we go to paragraph 63 of your affidavit, which you see on page 17, you detail Advocate Mokgoro coming to visit you in your office and informing you that he had received representations in the Mluli matter. Maybe you could tell us, accepting that that's there, what transpired at that meeting on the 5th of December. And can you remember at what time of the day that was?
It certainly was not early in the morning. If it probably was towards mid-morning or around about lunchtime, but it certainly was not very early in the morning, according to my recollection.
So Advocate Mokgoro comes to you. Does he bring anything with him to show you?
I think he had with him a folder of the, not a folder, a document of the Intelligence Services Oversight Act. I think he had the Intelligence Services Oversight Act with him. And I mentioned somewhere in my, either if not in this affidavit, but in other documents, that he also showed me in that meeting his proclamation, the proclamation appointing him as a special director.
Were you aware of that proclamation prior to him showing you it?
I was aware that he had been appointed as a special director.
And when did you become aware of that?
I'm not sure, but it would be shortly after his appointment. The exact date of which I don't recall.
And he came into your office and he informed you that he got representations in respect of Lieutenant General Mluli.
That is correct.
And did he give you these representations?
No.
And what was the conversation, to the best of your recollection, that ensued?
He told me that in terms of the NPA Act, a special director needs to consult with a DPP when he is going to make a decision. And that is common cause, because that is already in the Act, I'm aware of it. He then told me that he is dealing with these representations, his visit to me is towards fulfilling that consultation requirement. But he did mention that he is still going to look into the matter. I still remember that he mentioned that he wants to still consider the regulations that are attached to the Intelligence Services Oversight Act. That was basically the tenure of our discussion. And I must mention that the context of that is because Mr. Mluli at the time was, I think, the head of intelligence.
So your conversation with him centered around what you say in paragraph 64 of your affidavit. Would that be correct? The Section 7 of the Intelligence Service Oversight Act?
Yes.
Right. Did you reach any consensus on that day?
Consensus in what manner?
Any agreement in respect of the prosecution of Lieutenant General Mluli?
No.
On what basis did you part?
Well, we parted, as I say in paragraph 65, we parted on the understanding that he's still going to do some research on this matter. And the expectation from my side was that he was going to come back to me for further discussions.
Can I just get some clarity? What was the relevance of the fact that the issues here or the matter was in relation to Mdluli? Because he said he was still going to do some research and look, amongst others, into also the regulations, because Mdluli is the head of what, intelligence? Yeah, what was the relevance? Would he not have done that research had Mdluli not been the head of intelligence?
Well,
I don't understand the relevance.
I wouldn't be able to answer that. Maybe he may himself.
To the best of your recollection, how long did this conversation take?
Must have taken, what, 30, 35 minutes? Maximum 45 minutes.
You subsequent thereto received two memoranda from him, one addressed to you and one addressed to Advocate Breitenbach.
That is
That's
correct.
Right. What did you do subsequent to the receiving of that memoranda? And I'm going to take you to that memoranda in a minute. They were dated the 4th of December, and you will see them in the other bundle at page 68. Use the numbers in the bottom right-hand corner.
Yes.
Actually, the first one is at page 66 and the other one is at page 68. Correct?
That's correct.
So these were the memoranda which you then received
Yes.
from Advocate Mokgoro.
Yes.
And what did you understand? And I want to draw your attention specifically to paragraph 28, which you will see on page 77.
Yes.
What was your view once you've received this memoranda?
Well, I was surprised. First of all, because the memorandums were dated the 4th of December, which was a day prior to my discussions with Advocate Mokgoro on the 5th of December. But apart from the date, I was also surprised by the instruction that is given at paragraph 28, which you have pointed out. And around about the same time, after receiving my memorandum, I think I had a discussion with both Advocates Breitenbach and Advocate Smith in relation to the memorandum addressed to them as well.
And did they agree with you on did they agree with the memoranda? Did they express any view to you?
Well, the view they expressed, I might say, was also a view of surprise at the instruction. And receiving that memorandum caused me then to write to Advocate Mokgoro.
And Did you communicate with Advocate Mokgoro subsequent to your meeting with Advocates Breitenbach and Smith? You phone him? If you look at paragraph 69 of your affidavit.
Yes, I think I phoned him. And he informed me that he was out of town, but we could meet on the 9th.
I then take you to the bundle of documents which is at page 80.
Yes.
Is this the communication which you then sent to Advocate Mokgoro on the 8th of December?
That's correct.
Right. So let me take you through this document. Right. You detail that you had a discussion with him in respect of the Mluli matter, and you confirm the meeting that took place in your office.
Yes, I do.
Right? You gave him a copy of a memorandum provided to you by Advocate Breitenbach dated the 30th of November 2011, which is detailed in the top. And I just want to take you back a few pages to page 58 in the bundle. Is that the memorandum you're referring to?
Yes.
Has the same reference number 111/13711 on it, right?
Yes.
You indicated that in terms of the NP Act, he needed to consult with the DPP in certain circumstances. You indicated that the purpose of our discussion was to satisfy this consultation. He gave you a copy of the presidential proclamation on his appointment,
Yes.
correct? Your discussion centered around section 77CA of the Act, and you expressed the view that this is the relevant section that is critical in dealing with the matters of Mr. Mluli properly and correctly.
Yes.
You agreed with him that it empowered the Inspector General the powers set out in that section. That's what you detailed, and you parted on the understanding that he was going to conduct some research applicable to the intelligent environment of the police, respect of which Mr. Mluli worked. Correct?
Yes.
Right. You then detail the receipt of the two memorandums in the next paragraph, and you draw paragraph 28 and 29 to his attention, which is the next two paragraphs.
Yes.
Right? And you then, in the second last paragraph, say, you detail that you called him and that he was out of town and that your meeting would be set for the following day. And in the last paragraph, you say, I want to discuss with you is that I do not agree with your understanding as expressed in your memorandum that you can instruct prosecutors in the North Gauteng division in respect of which I am appointed as the DPP, irrespective of my views on the matter. As explained above in summarizing our meeting on the 5th, we do not discuss that you have prepared memoranda already signed on the 4th December 2011, in which you are giving the said instructions. Had you mentioned this aspect, I would have made my objection to your approach during our meeting. I'm also concerned that you indicate in your memorandum to me that you will advise the attorneys of Mr. Mluli of your instructions that charges will be withdrawn. I hold the view that such advice to the attorneys would be premature, as I do not share your views, nor do I support your instruction that the charges will be withdrawn. I hope that you have not yet communicated this to the attorneys, because if you have already done so, communication may have altered. I have also applied some thought on the involvement and role of the Office of the Inspector General of Intelligence in this matter, and even on that score, I have a different understanding to yours of how this office would be involved in this matter. I hope the above demonstrates the seriousness of the issues that we have to discuss, and I look forward to our meeting, and you ask for it to be rescheduled at 2 o'clock the following day. Is this an indication of the views that you held at that stage?
Yes.
Right. Okay.
Maybe I just want to the last sentence on the first paragraph where I say, because if you've already done so, such a communication may have altered. I meant there to say may have to be altered.
We all do these emails
Yes.
in a bit of a hurry, so we understand that that was
Yes.
what you intended to meet. Right. Who attends this meeting? You and Advocate Breitenbach and Advocate Mokgoro on the 9th of December.
Yes.
Right. Do you recall at what time of the day that was? 2 o'clock or 3 o'clock? 2 o'clock? In the afternoon?
Actually, somehow I seem to believe it was in the morning. I may be wrong. These things happened a long time ago.
Fine. I think that's on it. Prior to that meeting with Advocate Mokgoro and Advocate Breitenbach, do you attend a meeting with the legal advisor of the Inspector General's office?
Yes, we did.
And what is relayed to you at that meeting?
The discussions with the legal advisor of the IGI was essentially for her to confirm what the role of the Office of the Inspector General of Intelligence is. And I went to this meeting with Advocate Breitenbach and a member of the legal division of the police. I think it was a gentleman by the name of Brigadier van Graan. And in this meeting, the issues that we were going to discuss with Advocate Mokgoro, we touched on essentially the charges against Ms. Mdluli, and the response or the view of the advisor of the Inspector General of Intelligence was that the Office of the Inspector General doesn't investigate criminal matters. Those are investigated by the police. And I suppose that was because what we explained to her was essentially allegations of criminal conduct.
Was that exchange with Advocate Govender relayed to Advocate Mokgoro on the following day?
Yes?
So,
I think we may have told him. I don't see how we could not have, after we've been to the office of the IGI soon before we meet him in respect of the same matter.
how did the conversation, if you can, to the best of your recollection, how did the conversation ensue between yourself, Advocate Breitenbach, and Advocate Mokgoro on the 9th of December?
I had already explained my views to him in the email, so that was our point of departure. And I pointed out to him that, I don't agree that charges have to be withdrawn here. The briefings that I have been having and the allegation, the nature of the allegations, in my view, establish a prima facie case, and I couldn't understand how it could, or an instruction to withdraw the case could be made. And then Advocate Mokgoro's view was that, well, then I said, maybe in terms of the flow of the discussion, then I said, we sharply disagree on this, and Advocate Breitenbach was also of the same view, and the point was made in that meeting to the effect that, it would have been better if there was an NDPP, because we would simply go down the passage to the NDPP and ask him to resolve this impasse. And we all realize that, unfortunately, that possibility is not going to arise because there is no NDPP to go to. And Advocate Mokgoro indicated that as things then stood, he could not reverse his decision. He is functus officio, and in any event, his view was that there are investigations that needs to be conducted in this matter. Which we discussed briefly, essentially what the role of what the further role of the IGI would be in further investigations of the matter. And we discussed the point that this is a very, very difficult situation because Advocate Smith now, who is a senior advocate at a fairly junior level to us, is seized with two essentially conflicting views: an instruction to withdraw a matter in court the following day or the following week, an instruction that I do not support. And we discussed the fact that it would be difficult for Advocate Smith to go to the court on Monday and essentially tell the presiding officer that, Your Worship, I'm here with two instructions, one from the special director and another from the DPP, and they're at loggerheads.
What did you understand him to mean when he said he was Funtu Sufikyo?
That, well, he said he was Funtu Sufikyo. I suppose he could not, he's already made his decision on the matter. He cannot change it.
And did he relay that, did he inform you at that stage, or at which stage did you become aware that he had already told the accused instructing attorney of this decision?
He told us in the meeting. He said the letter to the attorneys is already gone.
What was your attitude in respect of that?
Well, I was still narrating the discussions, if I may conclude.
Sorry, Advocate.
Yes. So because of this possibility, I regarded that eventuality as an embarrassment. It would, in my view, bring the NPA into disrepute, where there would be two senior officials giving a junior prosecutor conflicting instructions. So in order to manage that situation, and after lengthy discussions, we reached an agreement that, all right, Advocate Smith can then go to court on the 14th and withdraw the matter. But I think a lot of emphasis was placed on the fact that this is a provisional withdrawal, premised essentially on the fact that there are further investigations that we all said needs to be done before the matter is re-enrolled.
And what did you understand that further investigations to involve?
Let me first of all point out, Advocate Bauer, that I had not read the docket in this matter. What I would receive were reports, and so I didn't have the full detail of the merits. But the one got the understanding that here, for instance, motor vehicles were bought, there were front companies involved, and so on and so forth. So the further investigations were basically going to relate to, how can I put it, strengthening the evidence that was available.
Okay. And let me put it to you differently. If the position had not been prevailing that the accused legal representatives had already been informed that the decision had been withdrawn, what would your position have been?
Yes, Mr. Ray.
Madam Chair, I know we're not in a courtroom, but this is very, very important evidence. And he has said nothing about the letter yet. What the evidence leader...
The letter.
Sorry, ma'am.
He has said nothing about?
He said nothing about having been told by Advocate Mwebi that the letter had been sent to the legal representatives, and now the evidence leader wants to introduce this, and not only introduce it, but already puts a slant and a perspective on the introduction, and it's a critical part of the document. He never mentioned it. It was always mentioned by Advocate Bawa with respect. So I know we're not in a technical courtroom, but I think there's some lines have to sometimes be drawn. Otherwise, the evidence just becomes completely worthless if the lead evidence leader is actually going to give the evidence. Then we might as well not even have the witnesses here. We can just deal with the affidavits with respect, madam.
Actually, I was going to ask a question because I was trying to understand the timeline. And I'm not, it's not in an effort to overrule you or to accept the objection, just to understand. At the meeting of, is it the 5th of December, you are told that the purpose of that meeting is to initiate a consultation process and envisaged in the law.
Yes.
Is that correct? At that meeting, you are not told that a memo has already been prepared the day before.
No.
Am I right? Am I correct?
Yes, yes.
At that meeting, you are told that Mr. Mwebi has received representation from the legal representatives of Mr. Mdluli. Is that
Yes.
correct? At that meeting, you are not told that Mr. Mwebi has already responded to the representations.
Yes.
The subsequent meeting of this meeting that we're talking about now, how did it come about that you're told that there's been an instruction to withdraw the charges? Are you told that I've instructed the prosecutors or I've written a letter? How was it phrased? I'm trying to understand.
Advocate Moroka, I met with Advocate Mwebi on the 5th, and then on the 6th, I received 2 memorandums dated the 4th of December. It is in these memorandums where he points out an instruction that charges must be withdrawn. I don't know whether that answers the question.
But yeah, he points out that charges must be withdrawn. But at what point are you informed, because you now say there was an embarrassing feature to all of this, at what point and how are you told that the legal representatives now know the situation?
In my email, you will see that and you must all be cognizant of the fact that this email was not responded to. The only opportunity to engage with this email between me and Mr. Mwebi was in the meeting in his office on the 9th. And then the discussions that I was still busy narrating are happening in his office on the 9th. And it is also in this meeting that I become aware that the letter actually has gone already.
Oh, okay, that's what I was trying to
Yes.
understand. So you're told on the meeting of the 9th that a letter has been dispatched,
Yes.
indicating that our decision is to withdraw the matter.
That's correct.
And the letter has been communicated to the legal representatives of Mr. Mdluli.
That is what Advocate Mwebi told us.
Just a follow-up question on that. What is your understanding of the provisions of Section 24(3), the in consultation? What do you think that requires of the special director and yourselves? Maybe you can give us an idea of what you thought or you believe should have happened in those circumstances where you had that first meeting with Mwebi.
You see, the it has now become settled law that in consultation in legislation means that there must be concurrence. But at that time in the NPA, you know, speaking for myself, I had always understood that the thrust of this requirement is that there must be concurrence between a special director and a DPP as envisaged in section 24 sub 3.
So that there can be no misunderstanding, can I take you to paragraph 76 of your affidavit?
Yes.
Page 21. When you say in this affidavit, Mokgoro further told us that he had already informed Mluli's attorneys of his decision. What are you meaning in that paragraph? Let me...
This is exactly what I've just explained now.
Right. The decision, as you've explained, that the charges are withdrawn.
Yes.
And he said because of this he was Funtusufikio.
Yes.
And then further in that paragraph, as you've explained, you would have ideally have approached the NDPP, but there wasn't an NDPP to approach.
Yes.
Right. Now the question to which objection was raised was, you had indicated that you had reached, let me see, had you already indicated that? Just hold on a second. Sorry, I'm just checking whether I'm mixing up what you've told me and what you've said in evidence. You earlier indicated that there was an agreement that the matter be provisionally withdrawn.
That's correct.
Right. And the question I put to you was, if Advocate Mokgoro had not already indicated to the accused legal representative that the matter was to be withdrawn, what would your position have been? In relation to the provisional withdrawal?
That Advocate Bauer is, I think now in the realm of speculation. You see, because the fact of the matter would still have been that I don't agree with him. Maybe if the attorneys had not been advised, one would have tried maybe to ask Advocate Mokgoro to reconsider his instruction. But the fact that a letter had already gone out to attorneys, in my view, was a weighty consideration, especially in view of the fact that the case was coming before court the following Monday, if I'm not mistaken, and Advocate Mokgoro and myself were in obvious disagreement.
You also mentioned that the issue was raised that certain investigations had to be done.
That's correct.
Right. Advocate Breitenbach expressed the view to this inquiry that that was all related to the IGI and that she didn't see that as a basis for the matter to be withdrawn. What is your comment?
I would agree with that because, I mean, my stance has always been that there is a prima facie case in these circumstances, and you just don't withdraw a prima facie case, well, for no apparent reason.
Sorry, can I just seek some clarity? There are terms that are being used which are a bit contradictory, and I'm trying to understand something. There's evidence that's being led that Advocate Mokgoro had said that he had already made his decision and he's now functus officio. And then on the other hand, there's the evidence that says that Advocate Mokgoro had said there were further investigations that needed to be done. And that speaks to sort of a provisional withdrawal. So you see, those terms are a bit contradictory because functus officio means final. Therefore, that decision has to be reviewed, not necessarily by the NPA itself. It has to go for judicial review if you want to change that. So I need to have an understanding of how did you understand the notion of functus officio versus the provisional withdrawal and further investigations, because somewhere there's something that's wrong with the terms that are being used interchangeably there.
If you go to my paragraph 76, I think the mention of functus officio is more clear there. You see, because the discussions in the meeting go along the lines of saying, you know, you have to consider withdrawing this decision, your instruction. He says it has already been committed. It has already been communicated. And in that regard, I'm functus officio. I cannot write back to him and say now, bring that letter. That, in terms of our discussion, should be distinguished from the discussions or from the discussions about the withdrawal of the matter, if one can say, on its merits. Because functus officio or not, I still held the view that there's a prima facie case here, which should not have been or which should not be withdrawn. So, to the extent that an instruction has been made, the agreement then was that so that the prosecutor does not have to say, I'm instructed to withdraw a matter by a special director with a DPP disagreeing with them, and it may not have been the elegant solution. But the agreement was that he must thus go to court and say the charges are provisionally withdrawn, with the understanding that in our meeting we said investigations must continue and this case is going to be re-enrolled.
Does it mean that Advocate Mokgoro had then changed his stance and was with you with regard to the need to withdraw only provisionally and then proceed with further investigations?
That is correct, Chair. And I want to emphasize that the discussions did not only stand there. The understanding was held by everybody that when these investigations are done, this case will be re-enrolled.
Thank you.
And let us be clear, Advocate Mzanyati, so that there's no disputes. I'm going to ask you again, what did you understand that investigations to be? Did you understand, did the issue come up, and I'm going to ask you this, did you discuss the merits of the case in terms of the evidence on hand, that certain evidence was required? What did that investigation entail?
We didn't discuss the merits of the case. I hadn't even seen the representations themselves.
So in your view, what did that investigations involve?
Well, we talked about the involvement of the IGI. Mr. Mokgoro, I still remember, he alluded to the fact that there are issues here that relate, for instance, to front companies, confidential classified documents. All those things may require the involvement of the IGI by way of further investigations.
Did Advocate Mokgoro inform you on any secret meetings he may have had with any members of the crime intelligence?
Secret meetings?
Confidential meetings that would have imparted any information to him?
No, I'm not aware of that.
Did he at any subsequent point tell you of such meetings after your meeting of the night?
No, I don't have that recollection of the Bauer.
When a prosecutor says to you a matter is closed, what is your understanding of that?
When one says a matter is closed, well, I suppose it should be the English interpretation. It's closed. There is nothing further that is going to happen in that matter. If I can use the analogy, for instance, of the DPP office where I work, if we say we close the matter, we withdraw the file and write on the cover, closed, so that the matter can go for filing. It's closed.
This decision on the 9th of December that you all agreed to, you explained at great length that you reached this decision because you didn't want Advocate Smith to get contradictory instructions. Did I understand you correct?
Yes.
Would you term that to be a principled and considered decision of the merits of the matter?
It's not. It's not, Advocate Bauer, and I mean, how can it
And
be?
he has already answered the question. He has already answered the question.
Advocate Mznyati, you were subsequently asked to provide a confirmatory affidavit in the freedom under the law matter. Is that correct?
That's correct.
Sorry, and I'm so sorry to disturb. It's just that in my head, I need to close another loop, and I need your help, because there is somewhere where Mr. Mzinyati does say this matter is closed. Can you just give us a reference?
It's page 118.
118.
Yes.
Can I refer the witness to that memo?
It's page 118 in the other bundle of correspondence, not in your affidavits, Advocate Mznyati. Look at the bottom, page 118.
Maybe can I start off? It's a memo to Lieutenant General Dramat, SCC Breitenbach, and yourself. Did you see this memo? Have you seen this memo before?
I'm sure I received this memo, Advocate Morocco.
And if you go to paragraph 4, you've just been asked a question about what does that mean. Do you see what stands there? That decision stands and this matter is closed.
This is what Advocate Mokgoro says.
So you do know about this decision?
I received this memo. Yes.
Okay. And this is your understanding?
That,
That the matter must now just be filed off and put away?
well, that's how. Yes, that's how I've just explained, Advocate
Thank you.
Morocco, my understanding of closed.
Sorry, while we're at that page 118, just to save us time going back to it, if you turn the page, you come to 119, which is the memorandum prepared by Advocates Breitenbach and Ferreira. Did you receive a copy of that memorandum? You're on the list of people to receive it. The one dated 13th of April.
I see that. I see this, and I'm sure I received it. I'm on the address list.
You're on the address list. Do you recall ever examining this memorandum?
Yes, I did. I do.
In fact, you were subsequently requested to provide Advocate Nxana with a report in 2014 in respect of the full matter.
That is
Do you
correct.
recall that?
That is correct.
And you attached to your memorandum to Advocate Nxana a copy of this
Yes,
memorandum.
That's correct.
Did you have any reason to disagree with the contents of this memorandum?
Well, this memorandum, Advocate Bauer, is written to Advocate Jiba by Advocates Ferreira and Breitenbach. They go through a lot of things here, but I think the aspects, and they are concluding by requesting Advocate Jiba to review Advocate Mokgwebi's decision. I think that is the basis or the rationale of this memo. To the extent that this memo questions the withdrawal of a case where there is prima facie evidence, I agree with its contents.
In fact, let me just check with my judge. Let me just proceed while they try to find that on the record. Right, so now we come to the confirmatory affidavit which you gave in the full matter. Right. What was the circumstances of you having given that affidavit? How did it come about?
You have already alluded, Advocate Bauer, to a consultation with Advocate Halchrein in his chambers in Johannesburg, and you have also alluded to a consultation with Advocate Lawrence Hodes in the NPA offices. Now, at this time, there was pending litigation that I was not party to. So the chronology of events then is that there is a meeting with or a consultation with Advocate Hodes, and at that time, I think I surmise from subsequent events that there was papers due to be filed, and I was asked in this meeting to outline my knowledge or my involvement in this matter insofar as it relates to my interactions with Advocate Mokgwebi. I did that in the meeting, and then I went away. As you've already asked me, Advocate Bauer, the impression was not created. I certainly did not, the impression was not created, and nothing made me to understand that I'm going to be expected to depose to a confirmatory affidavit. Then, on the day of the affidavit itself, I get a call from a colleague who works in our legal department and told me that actually the NPA needs to file later that morning, and there is a confirmatory affidavit that I need to depose to. Then he comes to my office, and it then transpired that I am confirming, or I'm deposing a confirmatory affidavit to Advocate Mokgwebi, who was answering an affidavit deposed by Mr. Grichler of Freedom Under Law. Now, I need at this point maybe to point out that the affidavit came with Mr. Chita of our legal department, already prepared. The urgency of the matter was made very clear to me. I then said, Mr. Grichler's affidavit itself was bulky, what that Mr. Mokgwebi is responding to. So I did not read the full affidavit of Mr. Krichler, so that I can relate it to what Advocate Mokgoro is saying for purposes of my confirmatory. I want to make that clear. But I then, with the limited time and the pressure that was brought upon to bear, said, okay, Mr. Chita, let's just quickly go through those parts of the affidavit where my name is mentioned, so that at least I can be comfortable that what I'm confirming is correct. We did that, and then what we found in the affidavit accords with what is already written here. And I was comfortable then to sign this confirmatory affidavit.
So, as far as you are concerned, that part of Advocate Mokgoro's affidavit that you were confirming was consistent with what he set out in your confirmatory affidavit?
Let me clarify this maybe, because I can point out that there's been criticism of this affidavit in other proceedings that I'm not going to get to. Criticism that I have subsequently explained in further proceedings myself. But in paragraph 2 of this affidavit, it is set out that whatever is said here should be accepted within its context. This is 137. Where it is stated that the facts set out herein are true and correct unless otherwise stated by the context and are within my personal knowledge. Now, the relevant parts of what Mr. Mokgoro is saying in his answer relates to our discussions in relation to the withdrawal of charges against Mr. Mokgoro. And you will see from this affidavit that from paragraph 7 at page 138, up to paragraph 10, we set out the discussions, basically the meetings of the 5th, as well as the meetings of the 9th, as well as the subsequent disagreements that were reached there, which led to the matter then being provisionally withdrawn. These paragraphs, I need to point out to the chair and the panelists that I regarded them to be consistent with what had transpired in my discussions with Advocate Mokgoro. And I was comfortable then with that background to sign the affidavit.
So, can I understand you when you say that there was an agreement reached and consensus reached with Advocates Mokgoro, what are you referring to?
The only stage, Advocate Bauer, where there was an agreement, and if you want to call it consensus, but the agreement was in the meeting of the 9th. And that meeting was, as I've already explained now, had its own purpose, which I've explained, and the effect of which was a provisional withdrawal of the case.
Can I get some clarity on just that point? On that paragraph 10, where you indicate in your affidavit that there was a consensus of a provisional withdrawal and further investigations. When there was that consensus, did that take away from your belief that there is still a prima facie case for the matter to proceed to court, albeit other investigations could still continue behind the scenes?
Advocate Vilakazi,
Ms. Vilakazi.
sorry, Ms. Vilakazi, the provision, the decision for provisional withdrawal had nothing to do with my conviction that there is a prima facie case. I mean, even though I was not privy to all the merits, but the broad allegations were obvious. The broad allegations were obvious that there was manipulation of loan agreements that related to the purchases of cars and so on. And I was told that this is unlawful in the fact that, or in the sense that private vehicles are being traded in for purchase of other cars through the use of the secret account and so on. So that broad ambit of the allegations I was aware of, which from my point of view sets out the prima facie case. Further investigations, you know, even if you've got a prima facie case, you still need further investigations. I think we all know that. So I don't know whether I answer you, Advocate Vilakazi. Sorry, Ms. Vilakazi.
Maybe you could just answer one more question for me. In as far as you and Advocate Breitenbach are concerned, were you both of a similar view, or were there issues on which you did not agree with Breitenbach on in respect of whether the matter, whether there was a prima facie case or in the manner of approach? Was there at any stage in your discussions, more specifically in that meeting of the 9th of December?
In the meeting of the 9th of December, the view that I and Breitenbach held was that there is a prima facie case. It is precisely for those reasons why the discussions had to be so detailed and protracted. It's because our view is that there's a prima facie case, and it really does not make sense to instruct for its withdrawal. I don't know if I'm answering you.
But the withdrawal was provisional, and you agreed to the provisional withdrawal. Is that because you hadn't changed your views or your stance regarding the presence of a prima facie case? And it is for that reason that you could agree to the provisional withdrawal?
That's correct.
Advocate Mzniati, did you have any involvement in the decisions to be taken to institute disciplinary proceedings against Advocate Breitenbach? You were present at a meeting on the 25th of November with Advocate Ramaiti and Advocate Karen van Rensburg when you met with Advocate Breitenbach. Is that correct?
That's correct.
Do you recall what transpired at that meeting?
Oh, sorry. Just for purposes of completeness, I need to explain that an attorney visited the NPA, I think it was Mr. Mendelo, with allegations against Ms. Breitenbach in terms of a case that was busy being, that was in the Kimberley High Court. Mr. Mendelo came with 2 Liver Act files, and he had called a meeting with them. He requested a meeting with the NDPP, Mr. Smelane. Mr. Smelane brought me in. Mr. Mendelo set out the nature of his complaints and said all the detail is in these 2 files. Mr. Smelane gave me the files and said, please take these files, go read them, and then I suppose either to advise him or for a recommendation. These files, or this complaint by Mr. Mendelo, I later came to understand that was the genesis of a chain of events that culminated in her suspension. But apart from, and I was giving that by means of background, then the case that was in the Kimberley High Court was being handled by the SCCU office of Pretoria, where Advocate Breitenbach was attached. Now, the meeting that Advocate Bauer is referring to was a meeting that was premised on a conclusion reached in the NPA that Advocate Breitenbach, in the context of these allegations, cannot continue to be involved in this case. She must then be removed from this case. Now, the meeting that Advocate Bauer is talking about, which I attended, is a meeting where I, as the DPP, Dr. Ramayite, I think at that time he was the head of the Special Prosecution Service, if I'm not mistaken, and Advocate van Rensburg, who was the CEO. We discussed the complaints, and the conclusion was that Advocate Breitenbach must then be removed from this case and still remain in the SCCU, dealing with other cases in the SCCU office. I do not have all the exact recollection, but subsequent discussions resulted in her, or in a decision that she is going to be removed from the SCCU altogether and be located in the office of the DPP in a different building. And that happened. And then whilst all of this was happening, she then subsequently got suspended. But I do not remember playing an active role in the suspension itself, myself.
At this meeting with Advocate Breitenbach on the 25th, Advocate van Rensburg's recollection is that the details and the identity of the complainant was not provided to Advocate Breitenbach. Would that accord with your memory or not? She didn't know who the Advocate van Rensburg says that the position of human resources was that Advocate Breitenbach was not provided with a copy of the complaint, and she wasn't told. She knew it related to the ICT matter in Kimberley, but she wasn't given a copy of the complaint or given the identity of the complainant.
I'm happy when you say she was aware that it related to the ICT matter. Whether she got the actual complaint itself in the two liver arch files, I don't know, because I subsequently gave those files to Advocate Mokgoro. I cannot, I don't remember whether we told him that the complainant is Mr. Mendelo. But one thing that was clear is that the matter was ICT. I mean, that is how, in fact, she understood that she's going to be taken from the matter. How can you be taken from a matter that you are not aware of? So I'm sure we told her that it is ICT, the Kimberley matter, and whether she knew if the complainant is Mr. Mendelo, I'm not sure, and I don't want to speculate there. Save only, maybe let me not make assumptions.
I have no further questions, Advocate.
Thank you, Ms. Bauer. You may proceed, if you're ready, with your cross-examination. And who's going to start?
Just Mokgoro, I have been deployed to do so.
Okay, to you then.
Thank you. Mr. Mzinyati, I'm not going to ask you many questions about Advocate Chiba. You clearly, in your evidence, said not much about her. But what I want to find out from you is, do you know Advocate Chiba?
I know her very well.
Can you tell us how you know her?
Advocate Jiba is a colleague of mine. We, at one point, many years ago, were junior prosecutors together in the lower courts in Amtata. We went to school together, both at the University of Transkei and at UCT. I could say that we are friends. She shares the same clan name as my mom, so in jocular form, I call her Umzala. She is she subsequently became my boss as the deputy NDPP. So I had to relate to her we've always been relating in a professional capacity, but I mentioned this because this is now a relationship where it is boss and subordinate, if you like. So in that relationship, we related very well and professionally.
You also, Advocate Breitenbach, who testified yesterday, reported to you, am I correct?
Yes, at some point.
She expressed very strong views about Advocate Jiba, and the views, for example, she believes that Advocate Jiba is one of the contributors to the demise of the NPA. Do you associate yourself to what is your comment on that kind of assessment?
I prefer not to comment.
Did Advocate Breitenbach ever discuss with you her views about Advocate Jiba?
Well, Advocate Breitenbach's views about Advocate Jiba, Mr. Masuku, are a matter of public knowledge.
No, but that's not my question. My question is, has she, in the context of the work environment, ever discussed her views about Jiba?
Oh, okay. No, sorry, I misunderstood. Well, I can tell you that she, for instance, after the memo that they prepared for Advocate Jiba, they held the view that she didn't take it seriously. I would say she was dissatisfied. Advocate Bredenbach was dissatisfied with the manner in which Advocate Jiba responded to this Mdluli matter.
Now, you've explained to us, to the panel, the meetings that you held with Advocate Mokgoro relating to the charging of General Mdluli, and you've also referred to the memorandum that was subsequently drafted by Advocate Bredenbach. Now, you've testified that you, save for just one aspect in the memorandum, you agreed with the memorandum, particularly the criticism against, the request to review the decision of Mokgoro on the basis that there was a prima facie case to prosecute General Mdluli. Am I correct?
I don't follow your question.
No.
Let
me rephrase it.
Please.
Let me repeat it. You've explained to us the meetings that you had with Advocate Mokgoro in relation to the charging of General Mdluli.
That's correct, Mr. Masu.
You've also told us that there was an agreement reached between the two of you, or between your team and Advocate Mokgoro.
If you are talking about the meeting of the 9th.
Yes, that's the meeting I'm talking about.
Yes.
That agreement, which was that the matter would be withdrawn provisionally, am I correct?
That's correct, sir.
And that you would, there would be further investigations that would be conducted. That's what you would convey to everybody.
Yes.
Right. You read the memorandum of Advocate Bredenbach.
Yes.
Right. And you know that she, in that memorandum, she criticized Advocate Mokgoro seriously on the issue of the instruction to withdraw the charges against Mokgoro.
Against Mdluli, yes.
Sorry,
Yes.
Yes. And that her appeal was that Advocate Jiba should intervene and basically set that aside.
Yes.
But in light of the agreement, what did you say about that memorandum and that request? In light of the agreement that you testified to?
The decision which we took was on the 9th of December. The matter was going to be before court on the 14th of December. The memorandum that we are talking about is dated the 13th of April 2012. I have since come to learn that in March of 2012, Advocate Mokgoro wrote correspondence in which he concludes by saying the matter is now closed. And it is in relation to that conclusion that this memorandum arose. So your question then was whether the views I had about the withdrawal of the matter are covered in this memorandum. The answer would be yes, if you are going to refer, Mr. Masuku, to the tenure or the understandings of our meeting in December. Because my understanding of the meeting in December is as follows. Prosecutor goes to court, 14 December, matter withdrawn. In the intervening period, which nobody knew how long it was going to be, investigations carry on until a stage is reached where the matter is re-enrolled. That is the understanding of the meeting of 12. Now, without being privy to what happened in the intervening period, then there is this note of 30 March that says the matter now is closed. Now the prosecutors are aggrieved by that and write this memo.
Yes.
So I'm saying, to that extent, I think with due respect and not talking about the content, but the fact that they were aggrieved, in my view, is valid.
So, I mean, you referred to an intervening period. Did you know if any investigations continued during that intervening period?
You know, you see, like I alluded to Advocate Power, I was not hands-on. So I don't know what exactly transpired, who went to which office on which day, which member of the police was involved, how many times they went to the IGI and so on. That detail I don't have.
Right. But when we saw that memorandum that Advocate Breitenbach and Advocate Ferreira drafted for the attention of Advocate Chiba, what were your thoughts on it? Just the approach?
The memorandum is quite lengthy, as I'm sure you're aware. It goes to 24 pages. They set out there.
Sorry, perhaps I'm not clear. Yesterday, Advocate Breitenbach, together with Ferreira, actually, they both testified that this was an extraordinary step to take by them, to have to write to Advocate Chiba to ask her to review a decision of Mokgoro. Is that what you also believe that was an extraordinary, unprecedented position by prosecutors to approach the acting NDPP at the time for her to review a prosecution decision on Advocate Ndluli?
Well, Mr. Masugu, I certainly would say it was an extraordinary step. They motivate why they are taking the step and conclude, if I'm not mistaken, towards the end of the memo by outlining the evidence itself, I suppose in an effort to say, this is what we have here, intervene because there's a prima facie case here.
And you supported that position?
Yes.
Now the last question, was this matter ever re-enrolled? And if so, what was the outcome?
The truth of the matter is that I'm not aware. I'm not aware whether it was re-enrolled or not.
Madam Chair, perhaps I should just take instructions from my team to see whether there's anything else I need to ask.
Can I ask a follow-up question to that question? The 9th of December takes a provisional stance, according to you.
Yes.
And between that period and 2019 January, under whose jurisdiction would this matter fall?
The matter was in the Pretoria office of the SCCU, and the Pretoria office of the SCCU is in the jurisdiction of the Director of North Gauteng. So it was in my jurisdiction.
And therefore, when you say you are not aware or you do not know, who should be taking accountability on the question of whether this matter should be re-enrolled or not re-enrolled?
In the normal course of events, Advocate Moroka, you know, as a matter of routine, cases do get withdrawn, either provisionally or even without the provisional condition. Representations follow, sometimes from complainants who are aggrieved. Some work is done. What I mean, as a matter of routine, subsequent to a withdrawal, several steps do happen. That happen very, very close to the coal face, without the knowledge of the DPP. So it is possible. It happens more often than not that withdrawn cases get re-enrolled and the DPP would be none the wiser.
Can I ask you a very difficult question? And if you can't answer, please say so. Because I would be intrigued by the fact that this case has always been in the public space. And for that number of years to get no resolution to it, whether it be the one that the Breitenbach and Smith were involved in, or the other extended matters that have to do with this case, how is it that, who do we ask about whether it's ever going to come to be prosecuted, or that the decision indeed is to close it for lack of evidence?
I am aware, Advocate Moroka, of efforts, efforts to get certain documents, for instance, declassified, which I think relate to this matter. And that process of declassification, from my recollection, has not yet happened. So I would presume that is one of the factors. It's at face value. If you listen to the allegations, somebody saying to you, A did this, B did this, then the result of that is that vehicle A and so on and so on and so on. Maybe that would be the simplistic understanding. But when you want now the actual evidence and the documents and so on, maybe that's why, because I do know that there is a current ongoing difficulty around certain declassification of documents.
But in your area of jurisdiction, as it were, North Gauteng.
North Gauteng, yes.
So in other words, North Gauteng would be responsible to the case proceeding or not proceeding. Is that what you say? Does the responsibility lie with North Gauteng whether this matter will proceed or not?
That is not entirely accurate, Chair. And let me seek to explain.
Just explain, kindly.
The structuring of the NPA currently is that you have got a special director appointed by proclamation to be the head of the SCCU. This is a person who has got if you like, a national footprint. In other words, everything that is SCCU, the special director is the top person, right? And there is only one of these special directors. He is sitting at head office. That is the position of Advocate Mokgoro currently. Then you've got directors of public prosecutions who are in the various seats of the High Court. Now, there are certain provinces where there is an office of the SCCU where you've got a regional head of the SCCU, as an example, in Pretoria, in Johannesburg, in Durban, and in Cape Town. Now, these regional heads report to the special director. Now, in terms of the NPA Act, the DPP, how can I put this? Okay, before I get to that, in addition to this,
And I want you to relate it to this case.
to the question,
Yeah.
there are also, just for purposes of completeness, there are also other offices or other provinces where there is no head of the SCCU. So you've got a province like the Northern Cape, for instance, where there is no head of the SCCU, and another place like, for instance, Limpopo or the Northwest. But there are, if you like, SCCU cases that happened there. Now, in that particular, and this is the dichotomy, Chair, that I want to attract your attention to. In that area where there is no regional head of the SCCU, but there are, if you like, SCCU cases in the sense that there are cases investigated by the commercial crime unit of the police, cases typically that would go to an SCCU office if you had one. Yes. In such a province, the DPP, for lack of a better word, plays the role of being the regional head for purposes of direct management, maintaining discipline in the office, and so on. Now, I want now to draw this closer to home in relation to your question, Chair, and Advocate Mokgoro. Now, in Pretoria, to the extent that there is a regional head, the relationship is, to use the terminology that other people like to use, between dotted lines and solid lines. You can say there is a dotted line to the DPP in the sense that they are they are in the province of the DPP. But the solid line in terms of accountability, reporting, and so on, happens between the regional head and the special director. So that's why I said to the Chair, it's not then entirely accurate to encapsulate this as a responsibility only lying on the DPP of North Gauteng. I don't know whether this answers it.
Ask a follow-up. During that period of the provisional withdrawal, for want of a better word, and January 2019, has there ever been a discussion between yourself and Mr. Mokgoro about this matter, taking into account the memos that have come through and the fact that there was going to be further investigation and the fact that there were some people who were appointed to further investigate these matters?
To the best of my recollection, Advocate Mokgoro, after our discussions and agreement on 9 December 2011, I don't recall me and Advocate Mokgoro having any further discussions about this case of Mokgoro.
Are we then to understand that when the memo said this matter is closed, that indeed the matter is closed?
Maybe Advocate Mokgoro, shouldn't this be a question maybe for Advocate Mokgoro?
I take your point.
Thank you.
I think I would like to know what your understanding is. Yeah. When the matter had been drawn provisionally, and thereafter it is said the matter is closed, what is your understanding that the matter is closed?
Speaking, Chair, from a slight disadvantage of not knowing what happened in between, But depending on what happened in between, there may be justification. But if nothing happened, or Chair, I need to be very careful here, because the conclusion that the matter is closed really depends on factors that I'm not privy to myself.
Fair enough. Going to consult, Mr. Masuku.
Yeah, in fact, in my consultation, I've been asked to ask for a 5-minute break. Or 10 minutes.
The comfort break?
In fact, he had said 15 minutes, but there are certain questions that I'm getting, the nature of which I need to just have a discussion with.
I think a response to your request has been superseded by a request which is absolutely necessary by the transcriber. So I think it is not necessary to respond to you. I will respond to him. Can we kindly have a 5-minute break and then you want 10? Okay.
Thank you.
10-minute break. Thank you, everybody. 10-minute break. Thank you.
Look, I can't because I know SABC voted you out.
think you may proceed with your deployment.
Yes, thank you, Chairperson. Advocate Mzinyati, you've given us your evidence on the memorandum that was drafted by Bredenbach and Ferreira. You are aware that that memorandum was copied to other persons. It was copied to Ramaite, it was copied to Hofmeyer, it was copied to Mkhwebi. Was there a reason that you could find that such persons should be included in this memorandum?
I don't know, Mr. Masuku, I don't know to speculate.
It's because, I mean, if the intention of the memorandum was to have, trigger a review by a specific functionary, in this case, Advocate Jiva, was it not awkward to you when you looked at this memorandum that other persons who were not decision makers, who could not make a decision on the memorandum, were being included in that memorandum?
As I say, Mr. Masuku and Chair, I don't want to speculate. I don't know why they included them.
Thanks. Following the memorandum, I'm instructed that there were a series of meetings. Or put it this way, following the memorandum, I'm instructed that Advocate Chiba had meetings with Advocate Mkhwebi on the memorandum. Do you know anything about that?
That's what Advocate Chiba tells you?
Yes.
No, I'm not sure. I'm not aware.
Okay. But she instructs me that there were several briefings that were held at her instance in which you were invited specifically to attend as the DPP, which meetings discussed the issues raised in the issue of Ndluli, which resulted in Advocate Becker and Filion being appointed to being appointed to prosecute them, to deal with the matter. Are you aware of that?
Now that you mention it, I do recall that Mr. Becker, who has since passed on, may his soul rest in peace, I am aware that at some point he got involved in this. That I cannot deny.
No, but what I'm asking you is
whether I was invited to briefings. Like I said, Mr. Masuku, I won't deny if a meeting is shown. I'm shown a date of the meeting where it was, but when I was testifying, I was speaking from immediate recollection.
Yes, no, it's fair enough. I understand it's a long time ago, but so there were briefings that were held. I'm instructed there were 3 or 4 briefings in which you attended, where this matter was discussed, and when Advocate Jiba eventually decided that the matter ought to continue being investigated, it was premised on these briefings that she had received during these meetings.
As I say, to the extent that I'm aware that Mr. Becker and another prosecutor got seized with the matter, and there may have been briefings that I was invited to, that I'm not going to deny.
Okay.
But I want to point out that when I testified, I didn't have immediate recollection of those.
No, it's fair enough. We understand. And then when Mr. Ngasana was appointed as the NTPP, he then removed the 2 prosecutors and appointed his own. Are you aware of that?
I'm not. Please remind me.
Yeah, I'm instructed that that's what happened. That when Mr. Ngasana got involved, or PKIP was appointed, he then removed Advocate Becker and Filion and appointed new prosecutors on the matter, so that the matter could continue being looked at.
Do we have the names, Mr. Masuk?
We don't have the names yet.
Yeah.
But we'll find the names in the course of time. It's Advocate Paul Law, that's the first one, and Anna Raso, yeah. Yeah.
Who are the two advocates who were appointed to replace Becker and the other?
I'm instructed they are Paul Law
It's
and Advocate
Arno Rousseau.
Arno Rousseau. Can I just ask, I mean,
Can I respond to that?
yes,
Chair, when I testified and mentioned about the difficulties that I'm aware of, especially in relation to the classification of documents, in relation to this matter, I'm aware that Paul Law is not Paul, man, Arno Rousseau, because he's in my office. I'm aware that he is part of the people who are busy trying to get these documents declassified. So that much I do have personal knowledge of.
These prosecutors were appointed by Advocate that were appointed Advocate Becker and Philium. Do you know them?
I know Andre Becker. Feliun, I don't have an immediate recollection in my mind, but Andre, I know.
But do you have any reason? Would you have any reason Do you have any reason why Advocate Becker would have been removed by Advocate Ngasana?
I don't think it's fair to ask me that question, Mr. Masoka. I don't know.
Yeah, you simply say, I don't know.
Okay.
Yes. And then of course, having said that between the period of the 9th of December and the period that went right through up until the memorandum itself and post the memorandum of Breitenbach, you really don't remember much during that period?
Yes, really.
Now, I mean, it's something that I'm sure Advocate Mokgoro will deal with in detail, and I don't hold a brief for him. But the issue is being debated on the issue that has been debated on his decision on this memorandum that he sent to General Dramat. You recall that memorandum which you were referred to in page 106.
Yes.
Sorry, 117 of the other memorandum of the other file. It's really a discussion on the matter closed. The issue, what your understanding was, that the matter stands and this matter is closed.
Which page again?
It's page 117. It's the pages that are underneath.
Oh, I see. Yes.
Right, if you see that, if you look at that memorandum, it was addressed to Lieutenant General Dramat. It was copied to Advocate Breitenbach and yourself, and it was from Advocate Mokgoro. You see that?
Yes.
And it was in relation to General Mduli's case.
Yes.
And if you read the entire significant paragraphs, paragraph 2, it says, I wish to advise that the Office of the Inspector General of Intelligence has no oversight functions and powers of review with regards to prosecutorial decision. I wish to remind that the NPA is an independent institution and prosecutorial decisions are its sole prerogative. The view of the IG following your solicitation of your opinion on the NPA decision on the matter based on a document which the police or anybody else were not even legally entitled to possess is for your consumption and does not affect the decision taken on the matter. The NPA took a principled and considered decision on this matter without fear or favor or prejudice as it is required to do in terms of the law. That decision stands and this matter is closed. You said you understood that to mean that the matter involving the Mduli's investigation, the matter involving the decision not to prosecute Mdluli at that time stood and was, so sorry, that you understood that to mean that Mokgoro's decision stood and the matter was closed. There was no further debate. You even gave an example of how you understood it within your office. Remember that?
Yes, that's what I was explaining my understanding of a statement that says the matter is closed.
But in context, would you accept that another meaning could be attached to that?
Maybe
within the debate of the powers of the IGI and the NPA?
Well, as I say, Mr. Masuku, my evidence related to a decision that the matter stands, the decision stands and the matter is closed. I mean, the decision that he talks about, I'm not sure. I suppose it's the decision that he took when he wrote the memos in December.
Yeah.
I'm not sure, but I was only answering a question of what do you understand.
Yes. But did you ask him? Sorry, did you ask him what he meant
after receiving this?
Yeah.
No, I didn't.
So, but if he were to give you an interpretation that is different to yours, would you accept that that's what he meant?
That would depend on the discussion, Mr. Masuku. That didn't happen.
No. I'm saying if you were to give a meaning, if Mr. Mokgoro were to give you a meaning different to your meaning, your understanding of the phrase, would you accept that that's what he meant and not what you say you think he meant?
I will not necessarily accept anything he tells me. We will have to discuss, of course, but the point of the matter is he will be saying, as far as I understand you, to me and saying, listen, Mzinyati, this is what I mean. What do you think?
Yes.
And I'm saying that didn't happen.
Okay. Now, you really don't know what happened in the Mdluli case. I mean,
as I say, Mr. Masuku, when I testified about, in response to a question by the chair, about attempts, for instance, to take this matter forward through having matters declassified, that is knowledge that came to me as a result of for lack of a better word, I think a briefing that had been requested by Mr. Abrahams, the former NDPP, where it then transpired that this advocate, Arno Rousseau, is struggling to obtain certain documents. So the answer to my question is, I mean, this was, I suppose, sometime last year, if I'm not mistaken, but to the extent that Rousseau was able to say, we are still looking for documents, that I would presume logically means the matter is still receiving attention.
Well, the matter was struck off the roll in July 2015 and has never been re-enrolled.
If you tell me.
Yes. The final question, Mr. Mzinyati, is there any, would you agree that what you've told us today does not point any blame for the delays or for the handling of the Mdluli matter to Advocate Jiba?
You want me to confirm that, or
No,
what is the question?
Yes, so I'm saying to you, what you have told us today, would I be correct if I said there is no blame at all that you can attach to Advocate Jiba in relation to the handling of Mr. Mdluli's case up to today?
Well, I mean, Mr. Masuku, it's not for me to attribute blame, but I mean, what I said about Advocate Jiba is what I've said under evidence in chief and now and under questioning.
No, you see, because the Mdluli case is a very important case, so yes. I'm surprised that you would have no view at all relating to whether it can be, from what you've told us, whether you can help us understand what you think Jiba should be blamed for in relation to the Mdluli case. Why is that a difficult case, question to answer?
Mr. Masuka, I'm going to repeat what I said. It's not for me to attribute blame. Whatever I had to say about Advocate Jiba was in my evidence.
Sorry, by the way, what did you say about Jiba?
Nothing much, if anything at all.
Okay. Madam Chair, those are the questions, that's the cross-examination.
And I thank you.
Thank you, Mr. Mzinyati.
Thanks.
Yeah, thank you so much. Advocate Bauer? No. Really? Oh. Mr. Rip,
Thank you, Madam Chair.
your turn.
Afternoon, sir.
Afternoon, sir.
Would it be correct if I say to you from your evidence and all the documents that we've seen today that on the 9th of December, and forget now the reasoning, there's a different reasoning, but on the 9th of December, at the end of the meeting between yourself, Advocate Breitenbach and Advocate Mokgoro, there was a decision taken that the matter would be provisionally withdrawn from the roll on the 14th of December, and the matter would then be further investigated.
Sorry, Council, your name is Advocate?
RIP.
Rip.
Yeah. But you don't have to use it, it's fine.
Advocate Rip, I think that accords with what I testified.
So, as part of that, if I can refer you to page 42 in the affidavit bundle, you made an affidavit in the, which case is it? I think it's the striking off matter, but it's at paragraph 139 on page 42 of that bundle. Do you see that?
Yes.
Pat? This is your affidavit, and you say at page 12, at paragraph 40 of his answering affidavit, Annexure SM7, Mokgoro says, an instruction was given to Advocate Breitenbach to manage the investigation of the matter.
Paragraph 138.
139.
Which page is this?
Page 42.
Oh, page 42.
Paragraph 139. An instruction was given to Advocate Breitenbach to manage the investigation of the matter. The fact that such instruction does not appear in the docket does not mean that it was not given. Moreover, Advocate Mzinyati was also present, and then you say, under oath, this paragraph is correct. This was part of the discussions of the meeting of 9 December 2011.
I see that.
And obviously you still confirm it.
Yes.
So the 9th of December resulted in the matter being provisionally withdrawn to be further investigated under the charge of Advocate Breitenbach to control such investigations.
Well, that's what I say. But, I mean, we all know that investigations are done by the police. But I'm saying that that's what is in my affidavit.
Is to manage the investigations, if you want to split hairs. Advocate Breitenbach had to manage the investigations. That's what it says, and that's what you confirmed.
Okay, I hear that.
Are you disagreeing with it now? I'm not quite sure what you're trying to tell me.
This is Advocate Mokgoro saying in his affidavit, isn't it?
Yes, but this is your affidavit.
No, but I'm saying what Mokgoro said there
Yes.
is what we discussed on the meeting of the 9th. Whether Advocate, the issue now is about the word manage, well, I'll wait for your further questions in that regard.
But are you disagreeing that she was to manage the investigations?
She was going to be, Advocate Breitenbach was part of the prosecutors involved in the matter. She was working with investigators. Whether she was going to manage it to the exclusion of everybody else, Well, I don't know whether that's what Mr. Mokgoro is saying here.
Mr. Mzinyathi, can I remind you, you are under oath now.
Yes,
And you were under oath when you made this affidavit that I'm reading from. This is your affidavit. And you say, under oath, this paragraph is correct. And now it appears to me that you want to tell me the paragraph is not correct.
I didn't suggest, sir, that the paragraph is not correct.
So then what is your problem with manage?
Well, I've already said this is what is in my affidavit.
So then on the 14th of December, the matter was provisionally withdrawn, and Advocate Breitenbach would continue managing the investigation.
That was the understanding.
Part of that was that the matter would then be referred to IGI, the Investigation General of Intelligence, for them to look into the matter.
Sorry, are you saying an agreement? That was the agreement? Or are you saying this is in the affidavit?
No, I'm saying that was part of the agreement, that the matter would be referred to IGI for them to look into the matter.
The matter would be further investigated with the involvement of the IGI's office.
So would it not then be referred to them to look into the matter? Why do you not want to agree with me? What is wrong with what I just said? The matter was referred to IGI's office to look into the matter. Is that not correct?
The matter was referred to IGI.
Yes.
Well, unless you can tell me where you find that from, Mr. Rip.
I will find it for you, since you want to be difficult. But I'll get to that now, when I have time to find the exact paragraph where you deal with it. Well, I'll put it to you in the meantime till I get that paragraph, that the matter was also referred to the IGI to investigate the charges against Maduli relating to the BMW 5 cars. Do you agree with that?
If that's what you tell me, I wouldn't deny it.
But you're the head of the department, sir. You are the boss of Advocate Breitenbach. You're the person we are told is in control of the office, and Advocate Mwebi is trying to usurp your functions, and you seem to know nothing about what's going on.
Brilliant.
Yes.
If you recall, I did say this is not a court of law. You're not going to ask questions in that manner, please. We are going to be very collegial about the questions and the answers, if you don't mind.
Please. If you want the truth, madam, or not, it depends on...
But there is a manner of asking the questions.
Well, we're in charge of the office, sir.
At what time? Because remember, Mr. Rip, I told you that how the offices of the SCCU are managed, if you want to recall.
The 9th of December. We haven't left the 9th of December. Are you in charge of the office on the 9th of December?
Yes.
Does Advocate Breitenbach report to you?
Yes.
Is it your view that Advocate Mwebi has no power over your prosecutors and can't tell your prosecutors, such as Advocate Breitenbach, what they can do on the 9th of December?
Now, whether, you see, and Mr. Rip, I want to be careful here, because you remind me that I'm under oath. There is one thing for Mr. Mwebi to make a decision. It's another thing to tell his prosecutors instructions of what to do. And I want that distinction to be clear, because the issue here that I took with Advocate Mwebi was a decision that needed concurrence. That's what I'm talking about. Whether you can tell prosecutors to transfer files from one prosecutor to another, I've got nothing to do with that.
No, my question was clear. Could Advocate Mwebi tell Advocate Breitenbach what to do on the 9th of December, according to you?
Yes.
And let's go to page 106 then. That is the start, that's in the other bundle, the correspondence bundle. you'll find that that is the letter, the so-called, let's call it the closed letter, for want of a better expression. You've got that letter, sir?
Yes.
You'll see that the letter is addressed to Lieutenant General Dramat, to Advocates Breitenbach and yourself, and the subject is the Silverton CAS number, the one about the BMW's fraud, theft, corruption charges. You in agreement with me on that?
Yes.
Now, what he says is, I wish to advise that the Office of the Inspector General of Intelligence has no oversight functions and powers of review with regard to prosecutorial decisions. That's on paragraph 2, first page. You see that?
Yes.
I also wish to remind that the NPA is an independent institution and prosecutorial decisions are its sole prerogative. Do you agree with that?
I see that.
Do you agree with that statement?
Yes.
Then he says, the view of the IG following your solicitation of an opinion on the NPA decision on the matter based on a document which the police or anybody else were not even legally entitled to possess is for your consumption and does not affect the decision taken on the matter. Okay, now let's just stop there for a moment and we'll get to the final paragraph. This document is being answered to a letter that came from IG. Is that correct?
Yes.
And that letter is to be found, oh, sorry, I did have it now, a few pages earlier, if I'm not mistaken. At page 81 of that bundle. It's headed Intelligence, Office of the Inspector General of Intelligence. Do you have that document? What? Sorry, page 112. Sorry, I'm referring, I beg your pardon, I'm referring to the wrong page number. It's page 112, I must refer to the bottom of the page.
Yes.
And that letter is dated 19 March and is attached to a letter that appears at page 111. And then you'll see at the top of that page, there's a reference there, 1/1/1/4, Lieutenant General A. Dramat.
Yes.
And it's addressed to Jiba and Special Commercial Crimes Unit. And it says, with reference to the memorandum of Advocate Mwebi regarding the ongoing investigation by the Directorate for Priority Crime Investigation into Silverton, attached is the response received from the Office of the Inspector General of Intelligence. See that?
Yes.
So now we know where the letter comes from. Let's go back to page 112. And in that letter, it says, we refer to your letter of 22 February 2012, wherein you requested an opinion on the reasons advanced by the National Prosecuting Authority for the withdrawal of the criminal charges against Lieutenant General Mdluli. In response to the memorandum of Advocate Mwebi of the 4th December, we advise as follows. And then the person sets out some information. And then on the next page, page 113, they come to a conclusion. And this Ambassador Advocate F.D. Radebi says, as such, we are the opinion, the reasons advanced by the NPA in support of the withdrawal of the criminal charges are inaccurate and legally flawed. We therefore recommend this matter be referred back to the NPA for the institution of the criminal charges.
I see that.
Fine. Okay. Now we go back to page 117. And you'll see that this letter is addressing that specific letter.
Yes.
And then it says, as I've just said to you, they say the view of the IG following your solicitation of opinion based on a document which the police or anybody else were not even legally entitled to basis for your consumption does not affect the decision taken on the matter. Then he says, the NPA took a principled and considered decision on this matter without fear, favor, or prejudice, as is required to do in terms of the law. That decision stands, and this matter is closed. Now, Advocate Mwebi will say, when you take this thing in the proper context, as my learned friends attempted to deal with you earlier, that decision that's being referred to there is the decision of 9 December 2011 between you, him, and Advocate Breitenbach, that the matter be provisionally withdrawn and that they will continue with the investigation. And this is being stated as against the statement by IGI that the matter must be placed down for prosecution again. So what he's saying is, my decision to provisionally withdraw it and further investigate the matter, I will not be told by IGI when or where or how I must prosecute. They have no authority to tell me when and where and what time I can institute a prosecution. My decision to provisionally withdraw the matter and further investigate it stands, and this debate between me and IGI and anyone else who wants to tell me when, where, and how I must set the matter on the roll is closed. Not the prosecution is closed, not that the further investigation is closed, not that nothing further will be done against Mr. Mdluli, but this matter relating to IGI and their attempt to tell me what to do, I'm not speaking further on it. Its matter is closed. What's your comment on that?
I'm not sure if, first of all, Mr. Mkhwebi addressed his concerns to the IGI and its lack of relevance, for lack of a better word, in this matter. But putting that aside, just look at how the paragraph itself starts. The paragraph talks about, and I presume, as you correctly say, that we're talking here about the 9th of December. The decision taken on the 9th was that the matter is provisionally withdrawn.
Yes.
He then says that decision stands and this matter is closed. Which matter?
The matter, the issue that's being raised in the correspondence.
Well,
Not the case is closed. If you will often read lawyers' letters where they dispute with one another issues and say this matter, this issue is closed. So you're turning the word matter into equivalent to prosecution or case. But I'm saying to you, this matter, what was intended in my instructions on, and I also read it like that, means this matter, this debate with IGI is closed.
but you see,
Because you see, if you mistake it into the context of his complaints above, his complaints is IGI is interfering with what he has to do and they have no power to tell him what to do.
I'm just trying to I hear what you say, but I don't know whether Advocate Mkhwebi ever did raise his, if I can call it, frustrations with the IGI to say, you know, you're not supposed to be interfering here.
He did, because the letter that was sent to him came from General Dramat. The letter from IGI was an attachment to General Dramat. General Dramat says, I've got correspondence from IGI, here it is. And he responds to General Dramat and said, I take issue with what IGI says to you.
This is precisely my point. Did he then also respond to the IGI?
But why would he have to? IGI never wrote the letter to him. The letter was written to General Dramat.
Okay, if you say so.
I'll put it to you further, sir, that at no time did the further investigation into Advocate Mdluli's charges on this aspect ever stop. You say that this letter says that was the end of the matter didn't go on any further, and I put it to you that this investigation never stopped.
Please, I did not say so. I was asked what my understanding of closed means, and I simply explained it. Now, if you tell me that things continue happening, then how can I deny that? I was only answering on a question, what do you understand by this matter is closed?
But then doesn't that support what I've just put you? That what Advocate Mkhwebi wasn't saying that the investigation or the prosecution or the case is closed. What he was saying was that dispute is closed and matters went on. The fact that matters continued, as you indicated, as was put to you, that Advocate Jiba had numerous meetings discussing the further prosecution of this matter, which you attended in the months that followed this letter, surely all indicate that the matter was never stopped.
Mr. Rip, you will recall that when I asked
Sorry, ma'am.
the witness what his understanding was, he said it depends on whether investigations proceeded or not, and he was not aware that investigations proceeded. So he is not aware, and he said so, that investigations proceeded, because if he knew, his response to my question might be different.
As it pleases you, ma'am.
Thank you.
And in addition to that, I've just responded to a question now, confirming, after being reminded, that Becker eventually got seized with the matter, as well as the fact that as recently as during the tenure of Sean Abrahams, the matter was being attended to because Arno Rousseau gave a briefing. So I will not deny when you tell me that the investigations continued.
Thank you, sir. The evidence that you gave about the documents that need to be declassified and the like, was that not in actual fact what Advocate Mokgwebi's concern was from as early as the 5th of December 2011? That because you were dealing with funds that came from the intelligence sector that were used for purchase of vehicles, that in order to be able to successfully prosecute this matter and prove the fraud or theft or corruption, you needed to have the background documents which fell within the jurisdiction of the intelligence sector of the police.
I've already testified to that, to say that is the understanding. And I gave reference as an example to other matters like incorporation documents of front companies. That is all documents that may need to be declassified.
So, to put it another way, Advocate Mokgwebi's doubts about a successful prosecution at that time without those documents were actually well-founded.
Advocate Mokgwebi's interest in getting those documents was well-founded. I agree.
The last question, sir, is I also have some difficulty understanding how you formed such a strong view on there being a prima facie case when you hadn't read the docket. Could you please explain that to the tribunal?
There are allegations. I am told the allegations. The allegations, very briefly, and I'm sure you are au fait with this. Here is somebody who is head of intelligence. He has got a vehicle that he wants, his personal vehicle that he wants to sell. The organization that he leads has got a contract with a vehicle dealer. Then his personal vehicle is taken to a dealer, and according to the allegations that I have received, a scheme is devised where a loan would be generated for him to receive 2 new vehicles in his personal capacity, but some of the money for those vehicles to come from the secret account. Those are the allegations. Now I'm saying at face value, if that is correct, that is prima facie fraud, or at best a form of corrupt gratification.
Well, certainly it's a very suspicious set of facts, but we're talking about being able to prove that there was fraud. So I understand prima facie to mean that you actually have enough evidence to show it, not that the circumstances. I mean, a man may get home with glitter on
Yeah.
his cheek. It doesn't mean he was at the wrong place.
Yes. No, I accept that.
You need to
that
go and get
possible?
evidence.
What could
Sorry,
that
man.
possibly mean, Mr. Rip?
What could it possibly mean?
On the cheek, you mean?
I think he was looking for a Valentine's gift for his wife.
Just to respond, Mr. Rip, I would accept that. Look,
I'm just trying to lift the mood slightly, sir.
yeah, indeed, thank you. I would accept that, but remember, Mr. Rip, when these briefings are given to me, I'm given these broad facts that I've just
Yes.
outlined to you, but the people who are witnesses in this case already say there exists actually certain documents. So the existence of the documents that needed to be declassified was not unknown. In other words, they already knew that there will be proof. If you go to this dealer, you will find ABC. So the broad facts I've given you should be understood in the context of investigators and prosecutors who know that there are documents, but that are not immediately available, if that makes sense.
So steps still had to be taken to be able to pursue the prosecution,
Yes.
actually start the trial.
Yes.
Much has been made of the fact that there was a decision to provisionally withdraw it, and we are aware of Section 6 of the Act, which deals 6A as opposed to 6B. So any withdrawal without a plea is actually a provisional withdrawal, to summarize. Why is it such a terrible thing to have where you've got to get documents declassified, all sort of other things happening, to provisionally withdraw matter and park it on the side and come back when you're ready with all your weapons?
There's nothing wrong at all with that. In fact, and if I understand your question correctly, that is precisely what we agreed on. And
Yes.
that, look, because of the preceding events,
Yes.
let this prosecutor now go to court and say the matter is provisionally withdrawn. You know,
And that's what happened as well.
that's what happened, yes.
Furthermore, you may not know this. Apparently, at about December, one of the other witnesses, I think Mr. Ferreira, Advocate Ferreira, indicated that certain other evidence started coming out about trips to Singapore and Hong Kong involving Lieutenant General Madluli. It might also have indicated improper fraud or corruption, other people being taken with who weren't supposed to be taken with, and the like. Are you aware of this?
I think those allegations do sound familiar.
And that those investigations actually now also started to expand and were pursued further against Lieutenant General Madluli from early 2012 onwards.
That I won't deny.
And that one of the reasons we would put to you that why the matter was maybe not put immediately back on the roll, because normally, as I understand it, the prosecuting authorities like to take a whole complete matter. They don't like to do piecemeal prosecutions. Prosecute him on one fraud charge, then prosecute him on a separate fraud charge. They try and pack it all together if it's possible to do so and practical to do so.
Well, I can accept that. Prosecution strategies differ. You know,
Yes.
others may say, listen, let's take this thing piecemeal for expediency. Others
Yes.
may say it may make sense to clean one, clean soup. So what you are saying really happens, but depends on prosecution strategy.
And that last thing I want to put to you is that Advocate Mokgoro had nothing to do with the prosecutions. In fact, our instructions are from July 2014. This matter and all things relating to Lieutenant General Madluli were removed from his office and were looked after by a different office. Do you have any knowledge of that? Can you deal with that?
No.
Yet, notwithstanding that 5 more
Sorry,
years.
Mr. Rip,
Sorry,
do you
ma'am.
know which office?
You took it over. I'm instructed it was sent to your office. But obviously to one of the prosecutors in your office or under your control. By the national director at the time. Mr. Nkasania.
Yes. Mr. Rip,
I can't click. Sorry.
I have already pointed out the involvement of an advocate in my office.
Yes.
This advocate, Arno Rousseau.
Yes.
Now, the involvement of Arno Rousseau, I don't know whether your instructions are that his mere involvement in the case means that the case is in my office. But you know, this is a very, very high profile matter. Maybe, Chair, if it was referred to my office, I would first of all I would like to confirm that and take it upon myself from now henceforth to follow it up.
No, I'm not fighting with you about it. I'm just
Yes.
it was in a question from the panel. The sole point I want to make is that many other people are responsible for what may or may not happen to Lieutenant General Madluli, and because that we are here partly, I think, or largely here because of the furor that's been pointed at Advocate Mokgoro in this regard.
Well, I mean, taking, and I don't want to belabor this point, but it has arisen now that investigations are continuing.
Yes.
You know, so, and that even to a certain degree, I confirm myself because the prosecutor in my office is involved, that I am aware of.
While they're conferring, let me just understand. At a point in can't remember the date, but there's a sense that you believe there must be in consultation dealings between you and Mr. Mokgoro.
Sorry, please.
That there must be in consultation dealings about this matter between the two of you.
Correct.
So in December, you're still consulting in the matter. In April, your view is very strong that you don't believe the matter should have been provisionally withdrawn. You disagree. In April. Withdrawn, I mean. You agree with Breitenbach and Smith that the matter should not have been withdrawn.
Oh, yes?
And you agree with that quite strongly.
Yes.
What I'm trying to understand is between April 2012, you are still of the view that because it falls within your area of jurisdiction, you should be consulted. But it would seem that time came and passed and there was no consultation between anybody and yourself. In fact, you don't really recall what has happened in this matter. Would I be stating that correctly?
I don't know, Advocate Moroka, whether the question is couched to ascribe some form of criticism.
I'm trying to understand what happened. Who took what decisions? You complained about the fact that you were never consulted and you disagree with some decision that was taken to provisionally withdraw. That's the last real impact of your decision, is that I disagree. I don't think this matter should have been provisionally withdrawn. So as far as you're concerned, between you and Mokgoro, there is then an escalation to Jiba. But I'm trying to understand what then happened. Who then has a responsibility? Who has the final say? Who, in terms of the law, has the final responsibility? I'm just trying to understand.
I think before you respond to that question, just try to arrange the facts in such a way that would lead you to responding properly to that question. Between the withdrawal of the charges and the provisional withdrawal of the charge. I think you need to make that distinction. Then it would give you an opportunity to answer that question.
And I assign no blame. I'm trying to
Yes.
understand the
She just wants
sequence
to
of
know the
events
facts. Yeah.
and the facts.
Just the facts.
Thank you, Chair. So we are now on the 9th, or maybe the 9th, I think, has been dealt with comprehensively. We are on the 14th now. The case is provisional.
I think tell us on the 9th, emphatically, what was the decision?
Okay.
In other words, the last decision that you, the last agreement between you and Mokgoro, what did you decide as a result of an agreement?
Chair, like I said, the decision of the meeting of the 9th, a lot of things came about. It's a discussion amongst 3 colleagues, even lawyers. So there'll be a lot of toing and froing, a lot of jargon gets into the picture. But the final decision, and we've considered everything now, the NDPP who's not here, all those things. We then say, all right, this case must be withdrawn on the 14th. The prosecutor must tell the court that this is a provisional withdrawal. The understanding is that the SCCU, Ms. Breitenbach, the representative of the SCCU in this meeting, a very senior official in the presence of the special director and the TPP, he's the head of the office, Breitenbach is here. The decision is, now, Smith, who is Ms. Breitenbach's advocate, junior, must go to court and withdraw the matter provisionally. But I think the important issue, Chair and panel, that one must gather from all of this is that we all take comfort from the fact that this thing is not being closed. It's going to be investigated until a time is reached where it is ready to be enrolled again.
Let's go forward to the 14th.
Then to the question that by Advocate Moroka.
Yes.
In an ideal situation, Advocate Moroka, the SCCU offices, they're very busy offices with a lot of work coming in and out, prosecutions being taken and so on and so forth. This requirement of consultation, if you go to the relevant section of the NPA Act, it only is triggered when the special director wants to make a decision, either to prosecute or decline to prosecute. That is when the special director needs to reach out to the DPP and say, I'm approaching you now in consultation. Do you concur or don't you concur? Now, in this particular, I'm giving that by way of background. In this particular set of facts, if there is no stage at which the special director has to decide, work can continue to happen without us having a need to meet until he needs to make a decision. Then the requirement becomes ready for implementation. So the lack of, what I'm trying to explain, Advocate Morok, the lack of consultation in terms of Section 23(4) should not at all be understood to mean that nothing was happening. It was only going to happen when he says, I am ready to make a decision, because that is what the Act, and the Act is very, very clear. He says when a special director is about to make a decision, either to make related to a prosecution or a decision to discontinue a prosecution, that decision should be taken in consultation with the DPP. I don't know whether I accept this, but I think what one is trying to explain here is that in this intervening period, if there is a lot of investigation, difficulties that everybody is experiencing and so on, the absence of a visit by the special director to consult doesn't take away the fact that if people say, no, we're busy with this, yes, I would expect, or the concern of the TPP would arise in a situation where he hears or she hears that in a matter of this kind, for instance, he has now decided to finally withdraw. If there was no consultation, then there would have been a disregard of that section. I don't know the answer you, Advocate Moroka, but I think that's the best I can take it.
Thank you.
Ma'am, I see it's just after 1 o'clock. Could we perhaps take the lunch adjournment now? We just want to take some instructions from our client and look at if we need to ask anything further. We will be, I think, if at most 1 or 2 questions after lunch, if any. If that would be in order with the panel and my colleagues.
The panel agrees that it will be fine. Yes, thank you. We adjourn. 2 o'clock.
At least I've told them already, you know.